Good morning. I'd like to welcome you to McInnes Cooper's first ever Hangout on Air, sponsored by Digital Nova Scotia. My name is David Fraser, and I'm a partner with McInnes Cooper. My practice is focused on internet and privacy law, working with Canadian and non-Canadian clients to address the requirements of Canadian laws and regulations. I've been working extensively with clients on complying with the new Canadian anti-spam law. As the clock clicks down to July 1, 2014, we've been getting many questions about Canada's new anti-spam law. These questions have been coming from large businesses and small businesses. They come from public corporations and public institutions. We've been getting many questions from American companies who are surprised to discover that the new Canadian law expressly applies to any electronic communication sent to Canada. Some are also surprised to see that it also expressly applies to electronic communication sent from Canada. The law is complicated and messy. It has a lot of moving parts, and it's not in one document. It has a number of strict general rules, but then there are a number of exceptions to those rules. The law also uses terms that most of us are familiar with, such as consent and existing business relationship. Unfortunately, these terms are particularly defined in the law, often in ways that are counterintuitive. First and foremost, it addresses much more than what most people would consider spam. It regulates not just unwanted and often fraudulent ads for counterfeit pharmaceuticals and inheritance schemes, but also all electronic communications made to consumers. It also applies to electronic communications made to businesses. We hope that this presentation will provide you with the essential characteristics of the new law so that you can begin to consider how it applies to your business. Please save your questions to the end, and we'll try to make sure that all your general questions are answered before we're finished. If you have any questions as we go through, please feel free to tweet them using the hashtag MCCASL, MCCASL, and we'll try to address all of those at the end. So before we start, of course, there's the mandatory disclaimer. This presentation is meant to be for educational purposes and should not be taken as legal advice. The law is very complicated. It applies to different businesses in different ways. As I mentioned, it has a number of general rules and a number of exceptions. Most businesses, in my experience, will require specific advice to adequately cover their individual circumstances. I also have a second disclaimer. Many times when I'm explaining to businesses about this legislation, they are very surprised at what it contains. They're surprised at the burden that it places on businesses and express that it is disproportionate to the benefit for consumers. So I need to say I did not write this law. It's not my fault, and please don't blame the messenger. I will also mention that I tried to fix it. In fact, I appeared in front of a parliamentary committee on behalf of the Canadian Bar Association, hoping to have some of these measures tempered, but was unsuccessful. So in this presentation, we're going to be talking about the background to the legislation. We'll go through the Act and the regulations, how those moving parts fit together. We'll talk about some key concepts. These are some of the terms that are defined in the legislation in somewhat counterintuitive ways. We'll go through the general rules, talk about the forms of consent that are necessary to be compliant with CASL. We'll talk about mechanisms for obtaining consent, and then we'll finally talk about enforcement before we answer questions. So the first question very often is, does Canada think you're a spammer? And in fact, yes, by and large. The photograph on the left is my son having a lemonade stand on the weekend. If he had emailed our neighbors to tell them about his lemonade stand, if he'd done that after July 1, 2014, he would be considered a spammer in exactly the same way as the person who sent the email message on the right involved in some sort of inheritance scam. Both are regulated by the legislation. Now, those two different kinds of messages are regulated in slightly different ways, however. So let's talk about the background to the legislation. Up until July 1, 2014, which is only a few short days away, there has not been a specific law in Canada addressing commercial electronic messages. We have privacy laws in Canada that address the collection, use of, and disclosure of personal information, which includes email addresses. We also have the criminal code that has specific provisions dealing with fraud, impersonation, and other such matters. But we haven't had them brought all together into one comprehensive scheme. And in fact, we've been lagging behind most of the countries in the OECD by not having an anti-spam law. So the law has been passed. In fact, it was passed in 2010, but is not yet in force. Most of it will come into effect on July 1, 2014. So how did we get here? And it's a useful conversation to have. Canada established an anti-spam task force in May of 2004. And that task force produced its report in May 2005. Those recommendations became the nucleus of the legislation. Previous bills had been put through Parliament, but not having been passed, came back, went through committee, went through consultations. And for those who are familiar with what happens when things go through committees, we ended up with a very complicated, cumbersome law. But probably most importantly, and this is one of the characteristics that many people have commented on, this law addresses spam as it existed 10 years ago. Spam in many ways has been addressed by technology. That very few spam messages, what you and I would consider to be spam messages, make it into your inbox. They mostly end up in your spam folder. So this legislation is lagging behind those times. So we have this law. This on this slide shows the full title of the Act, unfortunately. It doesn't lend itself to any snappy acronyms, but most people refer to it as CASL, Canada's Anti-Spam Law, or Canadian Anti-Spam Legislation, CASL. And what it does is it sets up a regulatory scheme. And so this slide presents the legislation itself, CASL at the top, and two different but very important regulations. We have the Electronic Commerce Protection Regulations, which are Governor and Council regulations. And then we have a telecom regulatory policy, which was set up after consultations but has the force of law by the CRTC, the principal regulator for this legislation. The GIC regulations include some very important definitions and also include what conditions are required in order to obtain consent, also for getting consent on behalf of others. The telecom regulatory policy, on the other hand, as there's a fair amount of overlap, talks about what are the consent requirements for commercial electronic messages, and what are also the content requirements, what needs to be in a commercial electronic message. And that's something we'll talk about in some detail during this presentation. The Act covers three things, although we're going to focus on the first part. It focuses on commercial electronic messages. It deals with the installation of software, principally going after spyware and rootkits and things like that, and also the alteration of transmission data, changing the transmission data of electronic communications in transit, for example, to hide who the original sender was or to redirect electronic messages. But we will focus on the first part, commercial electronic messages. The legislation contains some very broad general prohibitions, many of which have exceptions, and we'll talk about the principal ones in a couple minutes. So when it comes into force, the Act will generally prohibit the sending of commercial electronic messages without the consent of the recipient, and that consent can be express consent or it could be implied consent. It will prohibit altering transmission data in electronic messages, which result in the message being delivered to a different destination without the knowledge or consent of the intended recipient. Alteration of computer programs without consent, for example, to collect personal information or to engage in other mischief. It will prohibit the use of false or misleading representations online in promotion of products and services, and in particular, misleading content of commercial electronic messages. It will prohibit address harvesting and automated address harvesting, which is the practice of using bots on the internet in order to collect email addresses in order to send commercial electronic messages. Now, I've used the term commercial electronic message a number of times already, and it's critically important to understand how the law works to understand what, in fact, that means. So this is the definition from the statute. A commercial electronic message is an electronic message where it would be reasonable to conclude has as its purpose, or one of its purposes, to encourage participation in a commercial activity. And then it goes on to talk about what are the indicia, what are among the indicia of whether that message is intended to promote entering into commercial activities. It's important also to highlight that it's not just the content of the message in terms of an express invitation to engage in commercial activity, but it's also based on inferences that one can make from the content. So obviously paragraph 1 talks about an offer to sell purchase, barter, lease a product, goods, or services. Paragraph B talks about business, investment, or gaming opportunities. Paragraph C reinforces that by talking about any sort of advertisement or promotion of A or B. And then D is one of the more problematic ones and one of the more confusing ones. So if the content of the electronic message promotes a person, including the public image of a person, as being a person who does anything referred to in paragraph A through C, that makes it a commercial electronic message. It's unclear how broadly the CRTC is going to be looking at that. Many people have automatic addresses or signatures on their email messages that might include a promotional tagline, that might invite you to connect with them on LinkedIn, that might tell you about their products, certainly would tell you about what their role is in that organization, and that could be interpreted to be promoting the person as somebody who does those sorts of things. And so that may be enough to turn something into a commercial electronic message, because all that's necessary, you'll note, is not that it have as its purpose the encouraging the entering into of a commercial activity, but one of its purposes. So the anti-spam rules apply to electronic messages, and very importantly, it does not relate at all to the number of such messages. Many people, when they think of spam, they think of mailing lists, or they think of bulk emails, messages that are sent, the same message that are sent to multiple recipients. Well, this legislation will apply as well to one-on-one commercial electronic messages. Now, these messages need to be sent by telecommunication, although I'm not sure that there's any other way to send an electronic message. They have to be sent to an electronic address. And this is also a very important concept, and one that has caused some confusion. A message sent to an electronic address is usually one that's sent to an email inbox, so somebody's email address, to an SMS inbox, but it can include direct messages on LinkedIn, on Facebook, or Twitter. It does not apply to, for example, a Facebook status update, or a general tweet on Twitter, or an update on your LinkedIn page. It has to be sent to a particular electronic address. Now, of course, in order to be a commercial electronic message, it has to have the purpose of encouraging participation in a commercial activity, as we just discussed, and also of key consideration, particularly for non-Canadian corporations. These rules apply if a computer system located in Canada is used to send the message or is used to access the message, which makes things particularly problematic or potentially problematic for organizations outside of Canada, particularly those who might not be able to determine with any certainty where the recipient of that message is located. That individual, if they're using an email address with a .ca top-level domain, well, perhaps one should reasonably infer that it's going to Canada. But for Canadians use webmail, Hotmail, Gmail, Yahoo as much as anybody else, and so it'd be difficult to determine where those individual recipients might be located. But the legislation explicitly purports to apply if a computer system in Canada is used to access that message, which would include somebody's smartphone, somebody's desktop computer, or laptop. Now, fundamental to how this legislation works is the consent rule. Section 6, sub 1 says nobody will send a commercial electronic message to an electronic address unless they have the consent of the recipient. And that says specifically that consent can be express consent or implied consent. And we'll talk about how that works and the distinction between those two in a moment. And it also says no person shall send such a commercial electronic message unless that message complies with the content rules, which we'll talk about in just one moment. So you must have consent in order to send a commercial electronic message unless an exception applies. The content rule, which is in section 6, subsection 2, says the message must be in a form that conforms to the prescribed requirements as set in the regulations and must identify the sender, must provide contact information from the sender, and must include an unsubscribe mechanism in accordance with the regulations and section 11 sub 1. Some categories of messages are exempted or excluded from the consent rule, but are still included in the content rule. So messages on this slide, for example, you can send the message without the consent of the recipient, but you still have to include the identification, the contact information, and the unsubscribe mechanism. So for example, providing a quote or an estimate to an individual. You don't need their consent to do that, but you have to have the content rules abided by. Anything that facilitates, completes, or confirms a transaction. This is the sort of transaction after, for example, an online purchase where you get a message from the vendor telling you the particulars of that transaction, when the product will ship, for example. Warranty, recall, or safety-related information, you don't need consent, but again, you do need to have the unsubscribe mechanism, the identification, and the contact information. And then factual information about transaction, membership, or otherwise. All of these have to include the unsubscribe mechanism, the content rules. Some types of messages are excluded from both the consent and the contact rules. For example, employee to employee within the same organization, when that message is about the organization's activities. So for example, routine communications within a company related to the company's business don't need consent, don't need to include the identification, contact, and unsubscribe. But interestingly, if an employee within an organization sends an email to his coworkers talking about the car that he has for sale, he needs the consent of the recipients in order to do that, and needs to identify himself, have contact information, and have some sort of unsubscribe mechanism, which does seem somewhat absurd. There is an exception, and this is a very important one, but one where you need to tread very carefully, is employee to employee in different organizations. If the organizations have a relationship, and that message is about the organization's activities, the activities of either the sending or the recipient organization. We don't know, and there's not a definition in the legislation about what a relationship means. Can that be previous business dealings? Very likely. Can it mean they've collaborated together on projects? Very likely. But we don't have certainty in terms of how the CRTC is going to interpret this particular provision. So again, tread lightly. One doesn't need consent or conform to the content rules for an email message that's sent specifically in response to a request, inquiry, or complaint. Some messages in closed messaging systems do not need to have to satisfy either of these requirements. An example of this is, for example, an online banking portal where when you log in, you can receive messages from your bank. Those don't need to conform. Some have said that BBM and other invite-only instant messaging services would be captured within this, particularly because you have to choose the people you contact. You know their contact information from the system itself, and you can unconnect yourself from that individual and choose not to receive messages from them. Now, some registered charity and political party fundraising is expressly accepted, and those are specifically where it has a fundraising purpose. So let's talk about consent. Consent is key. You need express or implied consent to send a commercial electronic message. And in order to understand what that means, you have to look at both the Act and the regulations. The onus is always on the sender to prove that they have the consent that they needed in order to send the message. Now, many people have an understanding, an intuitive understanding about what implied consent means. You need to forget that when you're dealing with CASL. You need to, the only time that consent is implied is when it specifically is set out in the law and the regulations. Consent is implied when there's an existing business relationship or an existing non-business relationship between the sender and the recipient, or where the recipient has published and disclosed his or her electronic address without indicating that he or she does not want to receive unsolicited commercial electronic messages, and, this is a very important and, that commercial electronic message is relevant to the person's business role. So this has often been considered or often referred to as the business card exception. If I give somebody my business card without indicating that I do not want to receive commercial electronic messages, the person who I give that card to has implied consent to send me commercial electronic messages, provided they are relevant to my business role. Not their business, but it has to be relevant to my business role. So it's a limited category of implied consent. Likewise, if somebody publishes on a website, for example, my name and my email address are on the McInnes Cooper firm website in our directory, and it does not say I do not want to receive commercial electronic messages. So again, you can use that to send me a commercial electronic message unless I unsubscribe, or provided it has to be relevant to my business role. So what does this existing business relationship mean? Specifically in the legislation, it means a transaction within the past 2 years. So buying or selling goods, accepting a business opportunity, buying or selling land, or an interest in land, like a lease, for example. And so as soon as that transaction has concluded, that existing business relationship comes into being, and it sunsets after 2 years. All of these are subject to being vetoed by unsubscribing. It also includes the acceptance of a business opportunity within the past 2 years, a bartering transaction in the past 2 years, and importantly, a written contract in force or expired within the past 2 years. And so during the pendency of that written contract, there is implied consent, an existing business relationship for the sending of commercial electronic messages. And that, again, sunsets 2 years after that contract ceases to be in effect. Also, an existing business relationship includes an inquiry or an application made to a business in the past 6 months. And notice that these have different sunset dates. The inquiry or the application means that if somebody makes an inquiry of your business or an application with respect to any of your services, you can send them any kind of commercial electronic message for 6 months. It does not have to be related to that inquiry or application. All of these are subject to veto by an individual choosing to unsubscribe. An existing non-business relationship is generally not that applicable for most businesses. But for example, it includes a donation to the sender if the sender is a registered charity under the Income Tax Act of Canada in the last 2 years, a donation to the sender if the sender is a registered political party or candidate, again in the last 2 years, volunteering with a charity, political party, or candidate, again in the last 2 years, or a member of a club, association, etc. in the last 2 years. And the definitions of those are contained in the regulations. Now, how does one seek consent? So, because we have implied consent based on a set of facts that would exist, that the sender would have to prove, one can also get express consent. And after July 1, 2014, in order to get somebody's express consent, which is a form of consent that does not expire, you have to disclose certain things to them. You have to disclose to them the purpose for which you're getting the consent. You have to disclose the identity of the person seeking the consent, have to provide the contact information, at least a physical address, a mailing address to contact the organization, and at least one of an email address, website address, or telephone number. You have to tell them that they have the ability to withdraw their consent at any time. Now, this can be done orally or it can be done in writing. We're mostly seeing it being done in writing because it is somewhat cumbersome to say on a customer service representative script, for example, in one breath, the purpose, the identity, the address, the contact information, and the unsubscribability. Of critical importance is that sending somebody an email asking for their consent to send them commercial electronic messages is itself a commercial electronic message. So you cannot seek this consent by email unless you already have implied consent, for example, to contact that individual. Which is why we're seeing now hundreds and hundreds of organizations that are sending email messages before July 1 attempting to upgrade people either from no consent to express consent or from implied consent to express consent. There are limited transitional provisions that are important to know. Section 66 of CASL allows an organization to have implied consent until July 1, 2017 if there was a historic existing business relationship between the organization and the proposed recipient, and that relationship involved the sending or receiving of commercial electronic messages. So if you have an existing business relationship with an organization, let's say, or a recipient from 5 years ago, and you have historically sent that recipient commercial electronic messages, you continue to have implied consent to do that until July 1, 2017. And of course, that can be overridden by the individual's ability to unsubscribe. Effectively, Section 66 stops the clock, not only for the sunsetting of the existing business relationship, but extends that from July 1, 2014 to July 1, 2017. A number of questions come up regularly about how you can get consent using toggling. This legislation is expressly an opt-in regime. You cannot get consent embedded in other contractual terms. So, for example, you cannot have terms of service or a written contract with a customer that includes a paragraph that says they expressly agree to receive commercial electronic messages unless that agreement is broken out from the rest of the contract. And that checkbox cannot be pre-checked. The individual has to expressly themselves click that box and click I agree or confirm purchase or opt in. But importantly, there are certain ways online, for example, where you can get a person's consent just by having them enter their email address, as long as it is abundantly clear that they are entering their email address or SMS address or what other electronic address for the express purpose of receiving commercial electronic messages. And again, any consent form has to identify the sender, identify the purpose, have their contact information, which is a mailing address, and at least one of an email address, a phone number, or a website where that organization can be contacted, presumably so that organization can be contacted so that the individual can express their unsubscribe wishes. Now, the form of CEM, Section 6 Sub 2 that I alluded to earlier, it's key that an organization comply with these particular provisions. So as I said, similar to obtaining or seeking consent, you have to identify the person. Now, if the person is not the person sending the message, for example, you can have multiple organizations involved, or you could be doing affiliates, you have to identify who are all the senders of that particular message. You have to provide ready contact information. So, for example, if it's being sent on behalf of a group of companies, it is likely sufficient to include the contact information for the head office of the group, as long as that unsubscribe preference is propagated around the organization to the right place in a timely manner. And the commercial electronic message has to have an unsubscribe mechanism, which complies with subsection Section 11, paragraph 1. It has to clearly identify the name of the sender or person on whose behalf the commercial electronic message is sent, mailing address, as I said, and telephone number, email address, or website address of the sender, or the person on whose behalf this commercial electronic message is sent. The unsubscribe mechanism must be capable of being readily performed. So this means just a couple clicks if it's an unsubscribe link. This means certainly the CRTC has shown a preference for having unsubscribe mechanisms work using the same channel of communications. So allowing an individual and making it possible for an individual to reply to a commercial electronic message with unsubscribe or stop, or reply to an SMS with the word stop. The mandatory information in the unsubscribe mechanism must be set out clearly and prominently. It cannot be hidden. It cannot be in very small print. It cannot be in light gray type on a white background, for example. The unsubscribe mechanism specifically has to allow the recipient to indicate at no cost to them that they do not want to receive commercial electronic messages from the senders. As I said, there is a desire on the part of the CRTC that the individual should be able to use the same channel of communication. Importantly, whatever mechanism you choose, that mechanism has to remain valid for at least 60 days. So if there is a hyperlink so the person can click to unsubscribe, that landing page needs to be there and functional for at least 60 days. And the organization needs to be able to give effect to the unsubscribe request without delay, but no later than 10 days. So it's not sufficient within an organization to update their lists monthly. This needs to be done on an on-the-fly basis. Also, it's worth for organizations, certainly the legislation sets out a very binary approach, that I do not want to receive commercial electronic messages, kind of the nuclear option. A lot of organizations can comply with this requirement and still allow customers and potential customers to express their preference to receive certain kinds of electronic messages. It makes sense for that landing page, for example, to allow the individual to choose whether or not they want to unsubscribe from newsletters or notices of sales or different kinds of communications from the organization. The more choice you give individuals, the better. And also, a person who lands on that landing page and unsubscribes from one but keeps their subscription to others has probably given you express consent to receive all of those other forms of messages. So let's talk about how the rubber hits the road. As I've mentioned, the CRTC is the principal regulator of this legislation, and they seem to be taking their role as the enforcer very strongly. They seem to be very excited at the prospect of becoming law enforcement officers. One would have hoped that they would take a bit of a wait-and-see approach and a bit of an educational approach as July 1, 2014 approaches. But it seems to me that they are going to be quite aggressive out of the gate and are probably looking for some quick wins in order to get the word out that this is serious legislation. Contraventions of the legislation are usually determined with respect to administrative monetary penalties. So these are just like fines in the criminal context, except unlike the criminal context, there's a significantly reduced due process. The CRTC will simply levy administrative monetary penalties. The legislation and regulations set out the sort of things that they need to consider, and the onus is then on the organization to appeal that or seek some form of judicial review if they don't think that's fair or reasonable. An organization is also able to stop the imposition of administrative monetary penalties by entering into undertakings with the CRTC, which are likely going to be very onerous consent agreements that they will have to comply with. The penalties are very high, or the potential penalties, up to $1 million against an individual, or up to $10 million against a corporation. Also, officers and directors of companies can be personally liable for these administrative monetary penalties incurred by their organizations and the employees of those organizations. The CRTC, we expect, will name and shame violators for the deterrence purpose, and there is a due diligence defense that is available to those who might have inadvertently crossed the lines and contravened the legislation, but are able to demonstrate that they did in fact do all things reasonable in order to prevent that infraction from having occurred. Another enforcement mechanism, or quasi-enforcement mechanism, is going to kick in on July 1, 2017, and this is the private right of action. And so this will give an individual the right to sue for contraventions of CASL, up to $200 per contravention and not exceeding $1 million per day for unsolicited commercial electronic messages. I don't expect that on July 1, well, that's Canada Day, so on July 2, 2017, people will be lining up at the small claims court in order to get their $200. But I do anticipate the class action lawyers will be quite interested in pursuing these sorts of remedies on behalf of large groups of recipients of commercial electronic messages. The legislation sets out a list of factors for the court to consider in assessing statutory damages. And similar to with the administrative monetary penalties, there is the possibility of short-circuiting and precluding these sorts of damages, again by entering into an undertaking with the CRTC. So what should an organization do now? We're really counting down to the last days before July 1, 2014. Organizations need to have a very good handle on how they send commercial electronic messages, from where in the organization. They need to understand, they need information about all of their contact lists. That's not just bulk mailing lists, but all of their contact lists, in order to understand where those names and addresses came from and what consent might have already been obtained. Did you have express consent from the individuals? And we have some guidance from the CRTC that express consent in the pre-CASL days is going to be sufficient for express consent after CASL. It will carry over. But as of July 1, 2014, you will have to follow the strict protocols set out in the legislation in order to get express consent, which again is identifying the purpose, identifying the organization, providing contact information, and telling them they can unsubscribe. It's important to understand, for example, if you're going to use an existing business relationship that leads to implied consent, when was that last transaction? how long do you have in order to that you can send that commercial electronic messages, commercial electronic message. Organizations, of course, then need to start to adopt procedures to obtain and document consent. Seeking fresh express consent from the customer and contact list before CASL comes into force has been a common practice. As I mentioned previously, many organizations have been contacting everybody on their lists in order to try to move them over to express consent. And also in some cases they might be doing that in order to trigger the transitional provisions at Section 66 that require there to be a history before July 1 of sending commercial electronic messages. A lot of organizations are going to need to think about restructuring their databases or putting in place CRM systems to document this consent, to document the existing business relationship. When was the last sale? When does that contract expire? Or existing non-business relationships, and tracking the expiry of those and tying those into their messaging systems. As I mentioned, some have taken steps to trigger the transitional provisions by sending commercial electronic messages to those with whom they have a historic existing business relationship or existing non-business relationship. Certainly, you need to be ready by July 1 by modifying all of your messages that would be commercial electronic messages that fit into the requirement of Section 6 sub 2, which are the content rules, so that all of your messages going out meet those content requirements. Again, identifying the sender, identifying the organization, providing contact information, and providing a readily performed unsubscribe mechanism. Also, many organizations will need to look at documents such as contracts and agreements that they have with providers, particularly if those individuals do mailing list processing for them. It's extra critical if you are an organization that buys or rents mailing lists from others. You'll need to look at your internal privacy and email marketing policies and procedures so that individuals within your organization know exactly what they have to do. Documenting this thoroughly, I believe, is going to be key to a due diligence defense later. And then your published policies and statements. If your practices are changing, those likely need to be reflected in your marketing policies that might be customer facing, but in your privacy policies and privacy statements as well. So we are getting down to the very short strokes before July 1, 2014. A large number of organizations that don't feel themselves adequately prepared are quite smartly going to put a hold on most of their commercial electronic messages in the meantime until they have their house in order. They don't want to be one of the first organizations to be made an example of. So I would invite discussion and questions at this stage. There is a commenting function within the Hangout on air. Also, if you, as I mentioned in the introduction, if you have a question and would like to tweet it, you can do that using the hashtag MCCASL or McInnes Cooper CASL. And so I would open the floor to that. I don't have the Twitter in front of me, so I will ask if there's anything that has come through Twitter or through other mechanisms. So we don't yet have any questions through the Q&A mechanism in the Hangout, and nothing through Twitter. So I guess everybody's finding themselves to be quite comfortable with the legislation. Well, certainly after this, I hope this Hangout on Air has been useful and instructive. As I mentioned in the beginning, it's quite a complicated piece of legislation with many, many moving parts, and it applies to different organizations in different ways. And so, at least in our experience, it's been quite important for organizations to seek specific legal advice that applies to their own organization and their own practices. And so at any time, please feel free you can email me at david.fraser@mcinnescooper.com, or you can send me a message on Twitter, and my handle is @PrivacyLawyer. I have a question here from an individual who talks about working for a regulatory body. And let me get it at the question. Certainly, we have been doing a lot of work with regulatory bodies for those within professional associations and others. And one of the most important things that needs to be considered as they go through their compliance process is to what extent do they in fact send commercial electronic messages, or messages that might be considered to be commercial electronic messages. An important part of the definition within the legislation is that a commercial purpose doesn't necessarily have to mean an expectation of profit. And so some organizations that are not-for-profit but are not a registered charity, many of their activities can in fact be considered to be commercial. And so, for example, if you're a professional regulatory body and you are sending reminder emails to your members about their registration or their membership lapsing, or that they have to get their continuing professional development credits by a particular date, those would not be considered to be commercial electronic messages if that is the entirety of the content. And also there's the exception, the existing non-business relationship related to a membership. But certain solicitations, for example, related to certain professional development events or certain conferences or certain trade shows might be considered to be a commercial electronic message that would trigger these sorts of requirements. We found, unlike the privacy legislation, the federal privacy legislation that regulates the collection, use, and disclosure in the course of commercial activity is defined somewhat differently in that context. So there's a consensus that many not-for-profits are in fact out of that legislation. Well, this law focuses on the content of the message, and so professional regulatory bodies and not-for-profits are affected. They might not be affected in the same way as a private corporation or a public corporation, but they can be affected. So the question, I have a question here, how does a business maintain consent over time? Well, that's a very important question. The implied consent that comes out of an existing business relationship does expire. So most of them expire after 2 years. The other one, where it's in response to an inquiry or an application, that expires after 6 months. But the implied consent with respect to the business card exception or publishing an email address on a website, that does not expire until the person unsubscribes. Likewise, an express consent endures forever until the individual unsubscribes. And the implied consent related to a transaction, as I said, it expires after 2 years, but if you have repeated transactions with that customer, that 2-year period revives again as soon as that transaction is completed. A question's come up, and I think this is again in the context of professional regulatory agencies or professional regulators, about sending group emails to committees or branches within the organization. Well, you'll recall that there was one of the exceptions related to the ability from one employee to send an email message to another employee within the same organization for the organization's business. And so that would be within the same corporation. So for example, an example that I know very well would be the Canadian Bar Association. So within the Canadian Bar Association, those employees can send messages to each other, and they can send messages to members related to organization business. Now, messages from the Canadian Bar Association head office to some of its provincial branches, that would be likely covered in the provision that relates to separate organizations that have relationships one to the other. So you're probably okay on that. But again, I would be mindful of what in fact is in the content. And key to that is it has to relate to the organization's business. And that can be the business of one of the organizations or the other. I have a question. Will a copy of the slides be made available after the webinar ends? Yes. So we will be posting automatically on the Hangout page, a copy of the video through YouTube will be made available. And we will also post a link to the slides. And we'll also post it on the McInnes Cooper page related to the specific webinar. So individuals will have access to, at any time, a copy of the presentation slides and a copy of the whole webinar. Very interesting question. I pitch client stories to the media. Is this a bartering relationship that is covered by the 2-year implied consent? I wouldn't necessarily call it a bartering relationship. I don't think that the CRTC would probably fit that within there. But certainly if the contact that you have at the media has published his or her email address, and you are pitching stories which relate to that person's role in their organization, you're probably covered off within that particular implied consent. If they haven't, that might in fact be problematic. I would probably put this question in a bit of the gray area, I would be inclined to pick up the phone first and contact the person and say, can I send you this particular story? Because certainly if you're a freelance writer, you are looking to sell your services, or you are looking to sell a license to that particular article. And so that would be a commercial electronic message. But just pick up the telephone and ask them if you can send that story, and also ask them if you can continue to pitch them stories, and you're likely going to be able to do that. And sorry, and the question for Twitter is?
Where credit unions are member-owned, would that imply express consent and negate the necessity to obtain consent by July 1st?
Well, certain membership emails are covered off within the legislation, and you don't require consent for that. We've been finding when we've been advising financial institutions, certainly for their existing customers, if somebody has a current account, a loan account, or otherwise, very likely there is a written contract. There's a written banking agreement or an account agreement or a mortgage or a loan document which would satisfy the particulars of the legislation with respect to a written contract in effect. And so while that account is open, you have the consent, the implied consent, in order to communicate with that customer. And that ability to communicate with that customer is going to sunset after 2 years. But only 2 years after that account has closed. Prospecting would be treated very differently, because if you do not have the existing business relationship, the existing contract with that individual, you do not have their consent to send them that electronic message. So you would have to find a way to communicate with them through other channels, or to try to get a way that you would in fact have their express consent to receive email messages. I think those are all the questions that I've gotten so far through the Hangout. I'll pause a moment or two and allow anybody else who wants to do that. And we have nothing else through Twitter? No. Excellent. Well, again, thank you very much for joining us on this our first Hangout on Air. As I mentioned, the presentation, the full webinar will be available through YouTube on the Hangout page. We'll be sharing it through social media, and also we'll ensure to include a link to the slides themselves for anybody who might find it to be a useful reference. For those who are looking for specific advice about how the legislation affects their business, and I note again that this presentation has been necessarily general because it's a very complicated law, please feel free to reach out to me, david.fraser@McInnesCooper.com, by email. That would be my implied consent to send me commercial electronic messages. And also, please feel free to reach out to me on Twitter, where I'm @PrivacyLawyer. McInnesCooper.com has a number of resources and checklists and informative materials for those organizations that are looking to get more information about CASL or are looking for training materials in order to send through their organization. And we would be delighted to hear from you and delighted to help you with your compliance. Thank you very much for tuning in.